Hello. I want to welcome everyone today thank you all today for joining us for this webinar on citizenship stripping, exclusion and statelessness. Have counter-terrorism measures gone too far? This webinar today is being co-hosted by the Institute on Statelessness and Inclusion, Open Society Justice Initiative and Rights and Security International. I have the pleasure of moderating the event this evening or today, depending on where you are. And I have an incredibly esteemed panel who will be speaking to you about these incredibly important issues. The first on my panel will be Professor Fionnuala Ní Oileáin, who is currently the holder of the position of UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. We also have Edward J. Flynn, who is Senior Human Rights Officer at the UN Counter-terrorism Committee's Executive Directorate. Laura Bingham, Senior Managing Legal Officer for Equality and Inclusion at Open Society Justice Initiative, and Amal Di Chiquera, Co-Director of the Institute on Statelessness and Inclusion. Well, I think just before I introduce the speakers today, I also want to make reference to the very important principles that have been published. And I think you will all no doubt have seen them or had access to them. And if not, we will definitely share those on the Q&A function. The principles on deprivation of nationality as a national security measure were released, published 3 months ago, and they're being relaunched today, this evening, with a foreword by Professor Ní Oileáin. I think the principles and this discussion today is so incredibly important because what we are seeing is the increase in the use of citizenship deprivation exclusion in a number of different policy fields. And obviously it has incredibly significant consequences for people on a number of different levels. The area is obviously regulated also by a number of different legal regimes, be that international human rights law or international law more generally. And I think this is where these principles are so valuable in enunciating and providing us with guidance, states and others with guidance on how this measure should be used in a proportionate and human rights compliant manner. But I will say no further now, and I will introduce you to the first speaker. As I was saying, it is Special Rapporteur Ní Oileáin, and I would welcome you first. Now, I have a couple of questions that I'm going to ask. So my first question to you is, how do you see the practice of citizenship deprivation, exclusion and statelessness manifest in the work of your mandate? And what are the human rights implications of these practices?
Sure. Thank you, Yasmin. And I'm really pleased to join the seminar today, really pleased to join UNCTED, OSF, the Institute for Statelessness, and acknowledge also the value of having these principles and the work that's been done to produce them. They don't come in a vacuum, and they come in a very specific context, and that is in a context in which we see an increased use of citizenship stripping as a measure of use in national security contexts. And I think we should be clear that international law does allow for states to strip citizens of citizenship, but it's an exceptional power in international legal practice. And it's a power that demands very clear processes and obligations from states. And I think it's in particular the way in which the principles speak to the obligations and practices of states to remind states in particular that this isn't an unfettered power. It's not a power that should be exercised willy-nilly, and that in fact it's a power with significant practical consequences for individuals. So let me say a little bit about what the mandate has been seeing in its day-to-day work in relation to this. As I've said, we've seen the increased use of nationality deprivation in CT or national security context. I think there are two ways in which that is manifesting. One is that we've seen a great deal of changes to national laws, and I would refer those watching the webinar to a number of country assessments that the mandate has undertaken in recent years. So what's really interesting is that we see signaling around change to the law. And that signaling is really important because it does a number of things. One, without even activating the act of citizenship stripping, it speaks to and claims a particular kind of citizenship status, and in fact, distinct citizenship status for different groups within society, often leading to either de facto or actual stigmatization and discrimination of particular groups who have access to more than one citizenship. Those are often minorities, others, people who are seen as more vulnerable within the social system as a whole. So the first is changes to laws which serve a signaling function to particular groups, particularly minorities in society. The second is the actual practice, an increase in the actual practice of citizenship stripping. And there, I think we've seen particularly post 2014 and the significant number of departures of individuals to join the Islamic states and other non-state actor groups, we've seen a co-relationship between the assessments of threat and the passage overseas of nationals and the use of these citizenship stripping laws. And I will say that the other piece that goes with that is, in the mandate's experience, significant deprivations or limitations being placed on due process rights attendant to citizenship stripping. So it's not only that we see a change or a shift in states' willingness to use this measure, but also the kinds of remedies that are open to individuals to challenge are much less. And the case which the mandate has been most intimately involved with on this issue is the Shamima Begum case, the case pending currently in the UK Court of Appeal, in which the Special Rapporteur's mandate intervened formally. And there, what we were particularly concerned with was what we saw as the kind of stripping away of fundamental due process rights. And finally, just to say, the other pattern we are seeing in the use of these laws and practices is the secondary effects that they have on a whole range of other dependent individuals, those people connected with the individual who is being deprived of citizenship. Now, practically speaking, I think there's a real gender analysis hidden in this space, which is that often it is actually men who tend to be the individual who's most likely to be citizenship stripped. But the consequent results of that stripping have enormous effects for families, for dependent adults, and for children. So while it looks like it's a sanction that applies to an individual on their own, the mandate has also been deeply aware of the kind of broader familial and gendered effects of citizenship stripping in ways that may not be fully obvious from the target of a particular individual at a particular time.
Thank you so much. I mean, really important points that you raise around the impact and the issues that arise in the context of citizenship stripping. And as you say, the discriminatory impact, the due process rights, and the secondary impact, as you said, in gender. So really, really important points. The second question I'm going to ask you is, what is your response to states and who often say that the regulation of nationality is a sovereign matter, and that particularly in the context of fighting terrorism, it is not something that should be regulated and subject to scrutiny?
Sure, and I think we would all accept that we live in a world of sovereign states. That's the kind of Westphalian legacy that we all live with, and we recognize that states have particular powers and capacities under international law. They are in many ways the primary actors of international law and continue to be so. But I would say that the point here is that the limitations that are placed on citizenship stripping have in fact been placed on states by states themselves, meaning there isn't a third party out there somehow putting constraints on states. States have consentingly, through the process of treaties and customary international law, actually created limitations on their own capacity to citizenship strip. And the reason for that is, of course, is because citizenship is a gateway right. It's the right from which, in many cases, all other rights follow. From a human rights treaty perspective, because the state is the guarantor of rights and guarantor primarily through the sort of entry point of citizenship, the decision to take away citizenship is actually also a decision to essentially deprive access to a whole range of rights. So how have states limited their own capacity to limit citizenship? Well, the first, of course, finding for that is in the Universal Declaration on Human Rights, Article 15.2, in which states themselves, in the earliest articulation of common human rights standards and in the sort of aftermath of systematic citizenship stripping during the Second World War, prohibited the arbitrary deprivation of citizenship. In my view and the view of many other commentators, Article 15.2 is customary international law, laid down in the practice of states and adhered to by states as a matter of custom, even if they, quote, haven't signed the treaty. So beyond the UDHR, we have a number of other treaties that states have consentingly agreed to that limit what they can do in relation to this. So, for example, many conventions, I'm going to mention one specifically, the Convention on the Rights of Persons with Disability, recognize in express terms that you cannot arbitrarily take away citizenship. We also have some, if you want, specialized treaties in this area. So I do want to recognize the 1961 Convention on the Reduction of Statelessness, to which a number of states are parties, which again, states themselves created the treaty, states became party to the treaty, states practice what is required of them in the treaty, and that practice includes specific limitations on statelessness or the deprivation of citizenship by limiting what a state can do. So when states say to us, oh, we shouldn't be unfettered, we should do what we want in this space, actually, state practice, that's not consistent with states' own practice over a long period of time. And I think is very much an outlier view, notwithstanding that we continue to see some, a greater willingness by states, perhaps in the current security environment, to try to take back some of those things that they have committed to in previous times.
Thank you very much. It's very much appreciated. And I think it's absolutely really important to know, as you have, that this is not something that comes out of the ether, that this is something that has been regulated by states themselves. And there is a number of different international law, whether it's through customary or international human rights law or through treaties on statelessness, that this is regulated. And I think really important, as you've noted, is the incredible consequence for individuals and families of no longer having citizenship. I think in all of our work, we have seen again and again that it is one of the most significant consequences that can happen to an individual, because as you said, they no longer have access to the rights that others would ordinarily have, and they are literally excluded and banished. And I think that the effect of that needs to obviously be taken account of. And as you said, the importance of due process in the context of the enormity of these kinds of measures. So thank you for raising that and for so articulately explaining it. I'm now going to move on to our next speaker, EJ. EJ, so I've got a few questions for you from your perspective working in CTED. The first one I'd like to ask you is, can you please speak to the effectiveness or otherwise of the use of these tools of citizenship deprivation and exclusion in the context of counterterrorism, and what impact their use and consequences they have on international cooperation against terrorism and the promotion of peace and security?
Thank you very much, Yasmin, and thank you to the Institute for inviting me to participate in this event, and it's great to be on such a distinguished panel. The question of effectiveness is crucial to us, to the Counterterrorism Committee and to CTED, Yasmin. The Special Rapporteur quite rightly and understandably highlighted crucial human rights aspects of the question of deprivation of citizenship. But of course, she is also concerned, as we all are, about the question of effectiveness. But that's really our main focus. And so if you'll allow me, I'm just going to make a few observations in that respect, which I think go to how we look at the question of effectiveness. The issue of preventing statelessness is not, of course, at the core of the mandate of the Security Council's Counterterrorism Committee or the office I work for, the Counterterrorism Executive Directorate, but it is certainly highly relevant to what we do. Security Council resolutions have long reaffirmed, of course, that measures to counter terrorism must comply with international law, in particular international human rights law, refugee law, and humanitarian law. And as a part of the UN system, we cannot forget that the Secretary General has assigned a very high priority to the need to prevent and reduce statelessness. This is a humanitarian challenge that demands meaningful responses from the UN, from all of the UN, from member states, and indeed all international actors, because to be stateless is to lack one of the core legal attributes of being a part of the human family. Having nationality, on the other hand, allows the full development of one's dignity and the realization of human rights. And so the deprivation of nationality is a very serious matter indeed. Of course, for the Counterterrorism Committee, or the CTC, and for my office, CTED, the issue does intersect our core mandate from a rather particular angle. And I should stress at the outset that I'm not speaking today for the CTC. As you know, the members of the Security Council have substantially different positions on this sensitive issue, and the committee has not adopted a single policy position on it. But what we are, of course, focused on as core elements in our mandate are essentially two things: the prevention of terrorism and holding those who have engaged in acts of terrorism to account. In both of these areas, there are good reasons for us to raise serious questions over the imposition of or acquiescence in statelessness. As you're aware, the UN system, like many other actors around the world, is deeply concerned over the situation that has persisted in northern Syria in the aftermath of the military campaign against ISIL. There can be no doubt that the plight of persons stuck in the Al-Hol and other camps is a grave humanitarian crisis, not least because of the high numbers of children, including orphans, who are trapped there and whose citizenship is uncertain. In most cases, it does not appear that states of possible citizenship for these persons are at pains to establish contact with them and provide assistance, even though so many of these people are simply innocent victims of the large, irregular migration to ISIL-controlled territories from countries around the world several years ago. An additional concern regarding these persons is the potential revocation of citizenship in a small number of cases of persons, including women, who are suspected of having engaged in terrorist acts. Now, different states have different laws pertaining to citizenship revocation, which in a few cases coincide with their obligations as states party under the Convention on the Reduction of Statelessness. In most cases, revocation, if it is imposed, would occur only when statelessness would not result, that is, if the affected person has a second nationality. Obviously, that's the preferred situation. Such measures may not on their face be in conflict with those states' obligations under international law. And on this question, I would like to recognize the important contribution that has been made by the Institute in developing the principles on deprivation of citizenship as a national security measure. While neither the CTC nor CTED have endorsed the principles, it is clear that they contain many vitally important points of relevance to the way in which we promote effective counterterrorism measures, stressing, as we do, the need to respect such principles as legality, due process, and fair treatment, non-discrimination, and non-refoulement. That is a fundamental point on which I know we can all agree. But the question for those of us working in the counterterrorism field, working to promote the implementation of the relevant Security Council resolutions, is this: how does the failure to resolve citizenship questions, for example, for the many occupants of the internment camps in Syria, and the revocation of citizenship on grounds of alleged involvement in terrorism, in other cases, affect our goals of bringing terrorists to justice and of preventing future acts of terrorism? Is it, as you rightly wonder, Gasman, an effective counterterrorism measure? In the work of my office, we are strictly guided at the outset by the international legal obligations imposed by our founding resolution, Security Council Resolution 1373. That resolution requires states to take the necessary steps to prevent the commission of terrorist acts, and it also requires them to ensure that any person who participates in terrorist acts or in supporting terrorist acts is brought to justice. This is a duty that is owed, above all, to the victims of terrorist attacks. So how are those strategic goals affected if states choose to look the other way or to sidestep the need to hold terrorists to account simply by depriving suspects of citizenship? So the essence of the approach that we take to resolving cases of persons suspected of involvement in terrorism is to call upon states to implement comprehensive programs of accountability. In recent years, as you know, this has been situated under the rubric of the prosecution, rehabilitation, and reintegration of persons in accordance with Resolution 2396 of 2017, which dealt with FTFs. Now, certainly not everyone who traveled to territories controlled by ISIL is guilty of a crime, but states need to carefully assess the cases of persons subject to their jurisdiction. They need to pursue prosecution in cases where sufficient evidence of guilt exists or can be obtained. And in a fundamental sense, they need to take responsibility for persons who form part of their population and who in many cases grew up in their societies. I believe a strong case can therefore be made that the obligations laid down by the Security Council on bringing terrorists to justice may oblige states to take action in such cases to find ways of holding persons accountable if indeed they appear to have been guilty of crimes, and working to bring them back into society rather than simply depriving them of citizenship. I'm about to wrap up. I just would like to say that of course, the UN and the Secretary General himself has stressed that states need to be more proactive in resolving the desperate humanitarian situation of the thousands of persons, including children, whose nationality may yet be uncertain, who are still trapped in the camps in Syria, and the UN has issued certain guidelines in that respect. But the Institute has been very clear, and other international actors and the Special Rapporteur just now, about the serious humanitarian consequences of deprivation of citizenship. And we have to be aware that young people whose status is not regularized may be at grave risk of falling prey to those who would radicalize and recruit them. So we know this is a complicated situation, but I believe a strong case can be made for being proactive and for encouraging states to take account of these cases rather than resorting to deprivation of citizenship or failing to recognize those who may be their citizens. So I'll conclude by saying that, that this issue, of course, does not only apply to the situation in Syria. It's an issue worldwide where some states do impose citizenship deprivation as a national security measure. We don't take a particular position on that point, but our main focus is indeed the effectiveness of such measures and whether they help to ensure implementation of the Security Council resolutions. So I'll stop there, but thank you.
Thank you so much, EJ. Really important points that you raised, and I think very important more generally, as you said, from not only a legal perspective, but from a policy perspective in terms of how is the international community dealing with terrorism, and are we dealing with it collectively in a way that is responsible and effective? And I think you're absolutely right to say that states need to be thinking about this in the bigger picture and asking themselves questions about whether they are leaving the world and leaving their own citizens safer by, as you said, not bringing people to justice when they can and they should. and not dealing with or leaving people in the hands of non-state actors or in other areas where we know there are risks of further radicalization or radicalization per se. So I think these are really important questions that I think member states need to be grappling with, because what will end up probably happening is that we'll have this conversation in 10 years' time, but it will be a much different and worse conversation, unfortunately. The next question I have for you is more specifically about your work at CTED. And I think you alluded to this a little in your previous answer, but I wanted to know that does CTED look specifically at this issue of citizenship deprivation, exclusion, and statelessness, given the centrality of this measure to some of the counterterrorism policies of states? For example, do you consider this issue when you do country visits and in your follow-up recommendations? And how do you envisage that CTED will use and engage with the principles, notwithstanding that you have said that CTED to this date hasn't endorsed them, unlike, I think we have quite a number, like over 70 international experts who have, but I understand the limitations on CTED. But to what extent will you be, as CTED, engaging with these principles?
Well, we do very much, Yasmin, in cases where this is an issue. But for us, it's really a question of a topic for dialogue, because, you know, the way we approach our work in our visits and other activities is really to listen to governments, to discuss with them how they are attempting to deal with the problem. And we certainly take the position, in accordance with the guidance of the Counterterrorism Committee, to urge states to respect their obligations under international law and also to ensure compliance with international human rights law. So we're not dismissive at all about the serious humanitarian issues. That's certainly a critical consideration. But we also explore with states whether this sort of measure is really effective in dealing with the problem of terrorism.
Wonderful. Thank you so much again. We very much appreciate your insight on the panel. I'm going to now move on to Laura. And Laura, I want to ask you a couple of things. I'll obviously start with one. Can you elaborate for us the risk of executive overreach, which we've seen in many instances, related to the practice of repurposing powers to deprive nationality, say, for example, on grounds of fraud, to meet national security or other objectives?
Thanks, Yasmin, and thank you so much to ISI and to my co-panelists. It's just fantastic to be a part of this conversation and to be a part of relaunching the excellent principles with which my organization has a deep collaboration with ISI on. So let me just start by saying that loss and deprivation of nationality results from a broad range, a broad spectrum of state action, as the previous speakers have alluded to. And in some of the headline cases that we're more familiar with generally, we can identify similar fact patterns. Rohingya, Myanmar, Muslim populations in Assam, Dominicans of Haitian descent in the Dominican Republic. In each of these cases, it's easy to trace long histories of conflict and contested belonging, mass scrutiny of the population, deep narratives of othering and dehumanization. And in these cases, we readily see the importance of understanding the ideological causes of deprivation of nationality and how these relate to systemic social exclusion on prohibited grounds, and how contrary these actions are to the human rights framework, to the liberal international order, and avoidance of international conflict. The principles of deprivation of nationality as a national security measure are looking most directly in this sense at the thin end of the wedge. They focus on a part of that spectrum that I'm illustrating that draws on international and national law for its legitimacy and presents itself to the world as a public good that's necessary and calculated, strategic, and as EJ has said, effective is the argument. And yet state policies and actions are not hermetically sealed off from each other. just because they appear to be operating in different domains or executing on different objectives. And this interlinked spectrum of state power is why Hannah Arendt referred to fraud-based denationalization as an easy precedent. Acquisition by fraud is widely accepted as a justification for revoking citizenship, and it has a deceptively administrative or corrective character. So with this preface, I'm going to come to the question of executive overreach and purpose creep in the deployment of deprivation power. And for that, I'll focus on the relationship between fraud-based deprivation and national security using the United States as a case study. This is not to single out a particular country, but my organization released a recent report that looks specifically at denaturalization in the United States, or the stripping of citizenship from naturalized citizens here. And I have two main observations that I wanted to share that are linked to the findings from that study. The first is that citizenship stripping in general actually defies classification as a type of legal action. And its justifications are therefore usually slippery in reality and multiple. And so fraud alone is usually combined with the fact that the target of a prosecution is a threat to safety or a threat to national security. Deprivation is often classified, nevertheless, as a civil or an immigration matter, which legally denies its punitive nature in some of the signaling that the special rapporteur pointed to, and its links with detention in the case of statelessness or non-deportability of the person affected. So this means that executive power is often exercised without safeguards that would apply in a criminal prosecution, for example. And second, we must examine the tools of enforcement power behind deprivation cases and look at that are at the state's disposal, especially in the last decade. And this is where executive overreach and its wider societal impacts, I would say, are most obvious. States have unprecedented powers of scrutiny over populations today, and these tools, while extensive and purportedly scientific, are also biased and fallible. And the ability, with them, we have the ability to subject cases to investigation in bulk. And this also means that you need a formula to prioritize how to deploy denaturalization or denationalization, which invites, again, as I said, a secondary or a tertiary justification behind the selected cases. So let me turn now to denaturalization in the United States to illustrate a couple of these points. The statutes have been on the books for more than a century now, and never in the history of their deployment has fraud been the sole justification combating fraud in the acquisition of nationality. There's always a second and more ideological reason that matches with the politics of the day. So the history of enforcement, for example, against political undesirables during the Red Scares of the 20th century, the main impetus there being anti-communism rather than fraud. And the breadth of the statutes allows that to happen. More recently, under the Obama administration, and this is the practice that we focused on in our research, the intersection of denaturalization and bulk investigation tools began to emerge with Operation Janus, which was launched in 2010 and was designed to identify and investigate individuals with a final order of removal that had been entered against them, linked through their biometrics, through fingerprints in federal databases, with another record under a different name of someone who had later naturalized, the assumption being that the naturalization took place under a false name. Janus was eventually disbanded and as a formal operation, but a 2016 Office of Inspector General report highlighted that the enforcement agency had failed to digitize historical fingerprint records from the 1980s through the early 2000s that could be used to ramp up this further investigation along these lines. And indeed, when the Trump administration took office, they launched a second operation, Second Look, in February 2018. which envisioned up to 1,600 prosecutions under the statutes through a scrutiny of up to 700,000 or more immigration files. They were requesting a budget of $200 million in fiscal year 2019, and the 2020 budget requests reiterated this and cited an ever-expanding practice. So there's been a real escalation. For our research in 2018 and 2019, we obtained and reviewed case files for all denaturalization cases that were that were filed between January 2017 and December 2019, and filed FOIA requests for historical information. Through that information, we were able to show that, at least when it comes to civil denaturalizations, because there's civil and criminal denaturalizations in the United States, the Trump administration had already filed 3 times as many civil denaturalizations as compared to the average under the last 8 administrations. And these are only filings. As I said, the investigation was much, much broader. The use of historical fingerprint evidence to generate matches and the bulk review of 700,000 case files meant that some form of prioritization within the investigation was needed. And so the Department of Justice has indicated that it prioritizes cases based on the country of origin of the target, with priority going to special interest countries and neighboring countries. We found that 49% of the cases that we examined fell into this category, including countries of origin from India, Pakistan, Nigeria, and Bangladesh. Special interest countries are a fluctuating and opaque category of countries that are of concern to the national security of the United States. So this links Operation Second Look cases to national security policy, just as the Red Scare linked the prosecution of broad-based cases to anti-communism. It means that the racial disparities that have been associated with counterterrorism enforcement carry over into the corrective realm of broad-based denaturalization. Of the 60, what we know about the special interest country list is that of the 63 countries that have been on it at various iterations, 35 have populations that are majority Muslim, and of the 14 countries that have been on every iteration of the list, all 14 have majority Muslim populations. So this casts collective suspicion on communities of color in the United States, and akin to the ideologically driven Red Scare denaturalizations in their day, is more in line with the current administration's populist nationalism than either anti-fraud or counter-terror objectives. Many of the countries that rank highly in terms of country of origin of targets also present a risk of statelessness in our analysis, being that the country of origin wouldn't necessarily allow for dual nationality, leaving the person when stripped of American citizenship without a second nationality. The question that this raises for us is, it goes back to how do we assess the lawfulness of deprivation powers in the first place? What is it all for? And in the case of the United States, one of our findings is that the lack of constraints on this practice has meant that we're really unable effectively to even ask that question from the right perspective, or to answer it as a predicate question for why we have these statutes and why they operate the way they do today.
Thank you very much, Laura. It's quite chilling to hear the way that this measure is being used and the way that it's being, camouflaged, and very chilling in that how it can affect people, how it can affect civic space, how it can affect so much within society. I guess citizenship is such a fundamental right to all of us, and to know that it is being used or mispurposed in those particular ways is incredibly chilling, and has been, and is only being increasingly used. So thank you so much. And I really welcome everyone and suggest everyone does have a look at your brilliant report, because there's some really important findings and recommendations in that report. So I would definitely recommend that. And I will ask somebody to make sure that that report and the principles are made available in the Q&A function. And before I go on to ask you the next question, which I'm raring to do, I want to remind the audience that we are going to be putting aside 20 minutes for questions and answers. And we would encourage all of you to participate in the Q&A. There's a Q&A function on Zoom. Put in your questions in there, and then I'll be looking at those questions and picking them. But please do that as we go on. So Laura, just picking up on what you've been saying and the important research that you've done, is it an exaggeration to say that the institution of citizenship is under threat in ways it hasn't been for decades?
So I think it probably comes as no surprise that my answer to that question is a firm no. I don't think it's an exaggeration. And I venture to say that I think my co-panelists probably agree. It's the issue that brings us together today. And I don't think the United States is an outlier. And as I said, I don't mean to pick on any particular country. I think the real concern is the context of rising authoritarianism, intermingled with populism, rejecting principles of international human rights law, and what that means for the institution of citizenship and the check that international law does place on the practices that we're talking about, the instrumentalization of citizenship, particularly against minority groups. And there I want to highlight a recent article by Professor Tom Ginsberg, who's an American, and published an article in February in the American Journal of International Law, where he examines actually what the rise in authoritarian states in distinction to democratic states means for the very nature and practice of international law. I think that this is incredibly important to consider, given that there is a reserved domain still of discretion left to states in their internal law to govern nationality, to govern questions of citizenship. And so the importance of an international legal order and a human rights framework that puts in check some of those practices can't be overstated. And I think that in itself is also under threat today. And I think just going back to the symbolic nature of citizenship in that's made use of in the power grabbing, the rising authoritarianism, the deepening nationalism in so many societies, means that it's front and center in political debates and contests today.
Thank you, Laura. I think you put all of our concerns so incredibly succinctly in terms of this practice within the larger political context within which we live today, and the consequences of that and what that may mean for, as you said, minorities, political dissidents, others, is incredibly extreme. And I think we need to take this issue, as we were all saying, incredibly seriously, because it is such a fundamental right. And as you said, the foundation that regulates this activity, which is incredibly worrying, is itself being stripped away or dismantled. And so what does that leave us with is a really worrying picture. Okay, thank you very much for that. And we will certainly come back to you with questions, no doubt. I'm now going to move on to Amal, who was one of the principal authors of the principles themselves. And I have a couple of questions for you, Amal. I think you might need to turn on your video, Amal, because I can't see you. Maybe you have, and I just can't. Oh, nope, there you are. Apologies, you weren't in my screen. The first question I have for you was, the principles on deprivation of nationality articulate international law standards related to the deprivation of nationality. What are some of the main lessons to be drawn from the principles?
Thank you very much, Yasmin, for that question. And thank you to all of the panelists who came before me. you all have made my job a lot easier, I think, by covering so much ground and allowing me to pick and choose a bit in terms of what I would say. And I've obviously, no doubt, learned a lot already by just listening to the three of you. So thank you for that. I mean, before answering your question, Yasmin, I think I'm going to just take a moment to talk through the process through which we ended up with the principles, because that also shows the manner in which we scrutinized and looked at a range of different international standards in order to end up with what we have. And ISI and OSGI, as well as other partner organizations, the Assay Institute, for example, were involved in this process over 3 years, over which we consulted with over 60 experts from a range of different fields in order to come up with the principles. But the principles weren't developed in a vacuum. They obviously were a response to a specific context and a kind of a specific set of concerns that we had about the deterioration of the institution of citizenship, about the instrumentalization of citizenship, as Laura put it so eloquently. And it is in that context that we decided that it was important to go back to basic texts, to look at basic standards and fundamental principles of international law, and ask ourselves if actually the predominant narrative around the level of discretion that states have to deprive citizens of their nationality, if that actually is grounded in international law, and to what extent it is an accurate representation of international law. And so we looked at human rights standards, at international law standards, at humanitarian standards, and many others. And what we realized was that there was actually an entire basket of different types of norms and standards and principles, which apply to the very simple decision of whether or not a state can deprive someone of their citizenship. And what's clear is that a state should not have the ability to cherry pick and set different standards against each other. To say, for example, we value the principle of avoidance of statelessness, and therefore we will ensure that we are not going to make anyone stateless, but thereby that allows us to discriminate against people who have dual nationality. And the position that the principles take is that there is an obligation to look holistically at different sets of standards, different principles, and to be guided and to be limited by those standards in terms of how states pursue their discretion. And as the Special Rapporteur mentioned, there is no prohibition of deprivation of nationality. It certainly is allowed. It's allowed in very exceptional circumstances. And one of the conclusions that the principles draw is that it's very likely that a state would be, very unlikely that a state would be able to fulfill the criteria to justify deprivation of nationality on a national security basis. So if you look at the principles themselves, you can probably break them down into 4 different types of principles. I would say at the very core are the 4 standards which kind of shape and limit states' discretion in relation to the right to nationality, and in relation to who gets nationality and who can be deprived of nationality. And these are the right to nationality itself, the prohibition of arbitrary deprivation of nationality, the prohibition of discrimination in relation to nationality, with a particular emphasis there on race discrimination. As Dora mentioned, race discrimination is one of the main causes of statelessness. And of course, the avoidance of statelessness. And it's very important that states uphold and respect all 4 of these sets of standards when setting out policies and when taking decisions related to deprivation of nationality. So the prohibition of arbitrary deprivation, for example, it includes conditions related to whether there is a legitimate purpose. So why are you deciding to deprive someone of their nationality? Are you actually going to meet this purpose by depriving them of their nationality? EJ spoke of the issue of to what extent this actually works, and those are considerations that need to be taken on board. There are questions around proportionality. So deprivation of nationality is often a permanent measure. It's not like imprisoning someone where they serve their term, they rehabilitate themselves, and they are able to be reintroduced to society. It's a permanent measure which has a permanent impact on an individual and on an individual's dependence. So can you justify the use of deprivation when comparing it to the impact that has on the person? Now, these are all core principles, but then there's a second set of standards which also must be thought about. And these are the question of to what extent does the decision to deprive impact on other rights? So if I do deprive someone of their nationality, what does that do to their right to enter into and live in their own country? Or what does that do to the prohibition of refoulement? Or to the liberty and security of the person, or the right to private and family life? And these are all equally important considerations which must be taken on board. And when you look at all of these together, it becomes very difficult to justify deprivation of nationality on a national security context. There's a third set of considerations, which is to do with the actual process that's used to deprive someone of their nationality. And we're all aware, I mean, we've spoken about the Shamima Begum case as well. We're all aware that often when people are deprived of their nationality, or when people are subject to the law as a counter-terrorism or national security measure, that there is an erosion of due process rights. There's an erosion of the right to a fair trial. And so even if it may be justified in the context of the two sets of standards I just spoke about, it also needs to be implemented in a fair manner in compliance with procedural standards. And this too is very difficult for states to achieve. And so there are a whole range of standards, Yasmin, which come into play and which really, I mean, make it almost impossible, I would say, for a state to be able to, in good faith, say that the deprivation of nationality serves a legitimate purpose. It's not discriminatory. It's not going to result in statelessness. It is proportionate, etc., etc., etc. And if I can just conclude with a rather basic point and a rather fundamental point, but one which we often forget in defense of human rights law and human rights standards. And this is that we often, particularly when dealing with with issues of counterterrorism and issues of national security, we're faced with the argument that yes, human rights are important, but it's more important to protect the security of the state, or it's more important to crack down on terrorism. And so there is this rather convenient narrative of pitting human rights as a nice to have against national security, which is a must have. And there's always only going to be one winner in that kind of a kind of an argument. But that really is creating a straw man. And it's something that I think we have an obligation to expose for being a bit of a fallacy. Because as we all know, what the human rights framework does, it actually provides us with a framework through which we can take these difficult decisions, and we can balance different considerations against each other and come out of the process with our values and our principles still intact. So a human rights-based approach to national security isn't an approach which gives a free pass to terrorists, but it's an approach which addresses terrorism from a principled perspective, which does not result in the deterioration or undermining of other important values that we all cherish. I think I'll stop there for now.
Thank you so much. That was incredibly eloquent and well structured. There's obviously a lot of work that has gone within your organization and OSJI and many others to put these principles together. But it was incredibly informative to hear how you sort of broke them up into considerations and the layers of protection that persons have, or the steps that need to go through, the hoops that need to be gone through in order for a deprivation of citizenship to be lawful and justified. And as you said, in most circumstances, it would seem that it is not lawful nor justified. And I think what you say so pertinently was the fact that this is irreversible. It's unlike other measures. And I think in some ways, the gravity of it means, as you said, that there are so many hoops, but that is incredibly important to remind ourselves. And the fact that it is irreversible, and as Special Rapporteur Nia Lane said, it is the gateway to so many other rights. I think there are some really interesting questions around proportionality in particular in this circumstance, given the fact that it's irreversible and that it is in fact a gateway to all of those rights. But I'm sure those questions will come up. I want to ask you one final question before we do get into the questions from the audience. And I've seen that there are some really wonderful questions that have come through, so I'm looking forward to asking the panelists. But the last question I have for you is, so you've spoken about the legal considerations that states need to take account of. What other factors should we factor in when thinking about the issue of citizenship deprivation?
Yeah, I mean, there are a number of other considerations that I think equally important, if not more important than the legal considerations, because these go to very fundamental issues of the types of societies we want to live in and the value we attach to human life, which ultimately I mean, those are questions that the law should be serving rather than detracting from. I think you can look at it in terms of considerations in relation to the impact on the individual and the family and communities. You can look at it in terms of moral considerations, philosophical considerations, socio-political ones, and indeed geopolitical ones. I'm going to just pick 2, maybe 3, depending on how fast I get through them, because I don't want to encroach on the Q&A time. But just to give you a sense of some of the other considerations and some of the debates that we must be having when we talk about citizenship deprivation, and indeed when we talk about the institution of citizenship and its value and why we need to be protecting it in these times. One observation I have there is actually that we need to be thinking about the impact on democracy. So citizenship is a bedrock of democracy, and it's citizens who exercise democratic rights. And we need to be thinking about what we are doing to our democracies when we are undermining citizenship as an institution, and when we are undermining the rights of citizens, and when we are making citizenship something that can be given or taken away. Theresa May's famous words about citizenship as a privilege and not as a right. And these types of statements from political leaders, I think, need to be viewed with a lot of concern. I think there's obviously the impact on the institution of citizenship, but there's also the question of, and this goes more to the counter-terrorism space, I would guess, and so it's an issue that the Special Rapporteur and EJ would be more familiar with than I am. But the fact that the moment we start talking about national security and counter-terrorism, that the amount of leeway that's given to states, and when we say states, we really mean the executive here, tends to be much greater than in relation to other issues. And this also has a way of eroding at democratic values, of creating the context in which authoritarianism can flourish, of undermining the judiciary, of undermining the legislature as well. And so we really need to be wary of arguments which are for centralizing more power in the executive and holding or elevating the executive above the scrutiny of the legislature and the judiciary. And these powers are often taken in the context of citizenship deprivation, but they also have a way of impacting on other rights. We also need to think about what this means in terms of national sovereignty. who is the real sovereign here? And if the citizen who is able to vote in their representative is no longer secure in their citizenship, are we then undermining the very notion of sovereignty? I think there are questions around geopolitical kind of considerations which are also important. We often see a very unfortunate dynamic where more powerful, more influential states are quick to strip citizenship of individuals who they claim have the citizenship of a less powerful, less influential state. This is certainly the case in the Shamima Begum case. And I mean, under international law, the UK has no authority to interpret Bangladesh's law when Bangladesh has been very clear that Shamima Begum isn't considered as a citizen. So the fact that the UK feels competent to do so is an erosion and an undermining of Bangladesh's sovereignty. And so if we are to use the national sovereignty argument to legitimize citizenship stripping, we also need to look at the impact of citizenship deprivation on the sovereignty of other nations. A more simple way to look at it is in terms of a state taking responsibility for its own people rather than exporting that risk. I mean, there's plenty to be said about the impact on the individual as well, but maybe I'll stop there for now so that we can have a little more time for the Q&A.
Well, we certainly would love to hear more from what you're saying, because I think that the broader context within which citizenship stripping sits is incredibly important, because as you said, and I think it relates back to what Laura was saying, it's about the kind of broader political context within which we live now and the kind of society and governance structures that we want to have. And this is so deeply linked to citizenship, and it's so deeply at threat at the moment, given the kind of political situation that we find ourselves in and the world we find ourselves in. So thank you. So now I'm going to move to the questions, and we have a few questions. I will just pick, there's quite a few, so I'm going to pick out the ones that I think capture some of the other questions as well. So we had a question which I think picks up on some of what Amal was talking about in terms of proportionality. And someone has asked, can any of the panelists think of an example, real or hypothetical, where a deprivation of nationality could be necessary and proportionate, or even rational, if the objective is combating international terrorism? Amal?
Yeah, probably not. But I mean, I think my way of answering that would be to actually look at the two standards which are often pitted against each other, right? So there's the avoidance of statelessness and there is the prohibition of discrimination. And if a state wants to retain the ability to deprive nationality whilst avoiding statelessness, then that state is basically taking the position of discriminating against dual nationals, people of migrant heritage, etc. If a state decides that it's not going to discriminate, then it's not able to strip citizenship unless it says that it's going to be okay with people being made stateless. Now, the problem with either of these stances is that if a state says that it's going to protect people from statelessness, what it is in reality saying is that where a person would otherwise be made stateless, there are effective measures that can be taken which don't extend to deprivation of nationality, which protect the state and which protect against terrorism, etc. And so then the question is, why cannot those same measures be applied even where the consequence isn't going to be statelessness? And so I think that if a state is getting into this territory in good faith, it will find that there is always another way of dealing with these very challenging questions without resorting to the deprivation of citizenship.
Just to pick up on what you were saying, I'll get to you in 1 minute, EJ. So what Amal, just to quickly clarify, what are you saying the other measures are?
I mean, we would argue, and this is not our area of expertise. I think someone like EJ would be better equipped to answer that question. But we would argue that if someone has committed acts of terrorism, or the state has a reason to believe that they are about to be engaging in terrorism, that the criminal justice system needs to respond to that. And a person needs to be investigated and tried in accordance with due process of the law, and addressed through the criminal justice system. Because, I mean, let's not forget, most states have very advanced criminal justice systems, which have been set up to deal with very difficult and challenging crimes. And I don't see why it's not possible to also envisage terrorism and address it through the same lens. But like I said, I'm probably not the best person to answer that.
No worries. Thank you very much, though. It was a very good answer. EJ, over to you.
Thank you, Yasmin. It's a great question. It's something I've had the privilege of discussing, including with many now present in several forums that I participated in on this topic. I mean, I certainly didn't come to it as an expert or authority at all, but I've learned a lot. But one thing I have found is that, the question of the efficacy or the proportionality of this measure gets complicated if you introduce the fact that, it's sometimes, and maybe more often than not, introduced, not for kind of utilitarian motives, but because states take the position that individuals have, taken an oath of allegiance, have undertaken to conduct themselves in a way that doesn't place their country at risk. And is it out of bounds for a country to say, well, listen, you have plotted against the interests of your country, so why should we? And when you get into that kind of moral ethical argument, that's tricky terrain. But speaking really on my own behalf, obviously not for CTED or the committee, but I think we can all agree on the necessity of the principles of fairness and due process, and Amal and Laura have also addressed some serious issues of discrimination. I mean, those things must be avoided. But if we're talking about effectiveness, there's that obstacle. But I would say that really it goes back to a point I made before, which is that if you want to be effective, it is necessary for states to take responsibility to pursue criminal proceedings or whatever proceedings may be appropriate in these cases. One problem, and Amal referred to this, is, the word terrorism, and sadly I know this pretty well because I've been working in this field for a long time. It's a highly charged term, and it provokes strong reactions, and for good reason in many cases, obviously. But, when we think about some of the cases of individuals who may have been involved somehow, or who may have traveled with someone, or, certainly the cases of minors who had no criminal responsibility whatsoever. It's essential to place all this in an objective and deliberate and cautious context, and to, I think, in accordance with the council resolutions, to pursue accountability and then rehabilitation and reintegration. But sometimes the whole question of effectiveness, and I agree with the premise of the question, is kind of beside the point, because sometimes I believe that these measures are pursued for a reason other than effectiveness, because of lack of loyalty or honoring one's commitment.
Thank you, EJ. Does anyone have anything to add?
Yes, and I was just going to say, I saw the question from, I think it was Ian Snyderman at ICJ, and welcome in. So I think does it remain, do I believe it remains within the legitimate sovereign right of a state to strip citizenship? Yes, I think that still remains practice under international law. And I think we ignore that practice at our peril, because then we speak in a universe that doesn't speak to the practice of states. And I think that's at least, I suppose, the context that EJ and I both work in different ways. I will say, of course, it's arbitrary deprivation. So can we justify no, we can't justify it if it's done in a way that is arbitrary. And I think the key point is this was always intended to be an entirely exceptional measure. And I guess my only comment would be, and I think just bear in mind that we live in a world which is extremely messy, because the alternatives, and I say this as the mandate who also addresses what happens to people who have been stripped of their citizenship but remain within a particular state. It includes often not criminal justice measures, because our criminal justice systems are pretty imperfect. If we look at the scale of violations that have taken place in Iraq and Syria, and those are extraordinary and immense, the amount of accountability for victims has been minimal, none at all. In fact, the only accountability we see is mainly travel violations or membership of an organization. It does nothing to tell us what the scale of harms, the experience of individuals, and the accountability of those. So there's a huge accountability gap. And to be blunt, I don't think we have much of a capacity to fill it. And that's a real problem that we, notwithstanding the Security Council resolutions. So in the absence of that, what we see in a number of states is the use of other measures, particularly administrative measures. We see it in the UK, in the new pending legislation in the UK on the extension of sentences and other kinds of measures that may be taken against a person indefinitely who's suspected of being dangerous. So I think while I take the view, and the mandate certainly takes the view, that the creation of statelessness is unacceptable, I think we also have to be clear that the alternatives also run into a whole range. There are no perfect universes in the operations of what we can do and what states are faced with here. And many of the responses create another set of severe and compressed human rights challenges, none of which are easy. So so that we don't leave the conversation thinking there's sort of an easy universe of non-human rights violations that follows from, I think the challenging part in this terrain, which brings us back to a more fundamental question, which is how do we address the conditions conducive to the production of violence, to the use of these measures, to the structures within states and others that have continued to perpetrate a set of responses to conditions that are ultimately not resolving the fundamental challenges that our societies face.
Thank you very much, Fionnuala. I think there's some really important points in terms of zooming out and seeing where this all fits. And as you said, acknowledging the extent to which it is a permissible action, citizenship stripping, but there are significant regulations around it. And I think, as you said, a very good question from Ian Siderman. I'm going to sort of collate a few of the questions. There are a few questions being asked around the discriminatory impact, particularly given that in a lot of cases, countries are obviously have laws whereby they say they can deprive persons of their citizenship only if they hold another citizenship, thereby complying with their obligations not to make someone stateless. So they are ticking a box in one regard, but obviously this has significant and potentially disproportionate and discriminatory impact on migrant communities, ethnic and racial minorities. How did the panelists square these two things together? The obligation to not make someone stateless, therefore we can deprive in circumstances where they hold two nationalities. But what that means in practice, for example, those in the UK, we've seen, migrant communities fearful of this being used against them in particular. I'd be very interested to hear the panelists on this. Does anyone in particular want to
Well, maybe
answer?
just say the mandate, I'll just say very briefly, we've addressed this in a number of reports around the concerns around two-tier citizenships and the ways in which we get stratified citizenship and the consequences of that for the full equality and integration, particularly of minority communities within the body politic. And the second is the chilling effect that the potential for being made subject to citizenship stripping has on the full enjoyment of a person's rights, including in particular freedom of expression, freedom of assembly, rights that persons may feel they are limited in their exercise of, precisely because the consequences, particularly in repressive or states that don't brook criticism, and that has an increasingly large number of states, will mean that they risk this kind of ultimate penalty. And I think the third piece about it is that, and I think the point made by Amal was a really important one about sort of two-tier sovereignty, where in fact one group of states can essentially subcontract what their perceived problematic citizens to another group of states. And I think it's particularly obvious in the Begum case. And I think the mandate's view is inconsistent with the 1961 convention. If you're going to citizenship strip, the requirement is that you have, where there's dual nationality, that you seek the engagement of the other state. And that was not sought in the Begum case. It's very simple. Procedurally, they never asked. So ab initio, that would seem to just say this is not consistent with the state's treaty obligations. But there was something, I think, quite challenging, a sort of a neo-colonial specter of having a number of experts speaking about Bangladeshi law in a SIAC hearing in a way that I think undermines the legal integrity of Bangladesh, and in ways which I think the state found particularly challenging. And so I think all of those things, Yasmin, are relevant to this challenge of sort of the two-tier problem, the stigma problem, the chilling effect problem, and the lack and potential for lack of enjoyment of equal rights for persons who have dual citizenship.
Thank you so much. Laura, I think you had your hand up to respond.
Yeah, just another small contribution from me. I mean, and I'll fold this together with the answer I was thinking of to the last question, to Ian's question. Well, I mean, to me, I think these are, as concepts, irreconcilable. I mean, that's how we saw them, and just reflecting back to the process that Amal described, that led to the principles themselves. We had debates and discussions with experts about an analogy to abolitionism in the death penalty context, right? And I spoke about the United States. In the United States and the administration of the death penalty, and attempting to do it in a way that respects the principles of the Constitution, including due process and equal protection of the law, has led many a Supreme Court justice, to throw up their hands and say, I will no longer tinker with the machinery of death. That's Harry Blackman. But I think that there's an analogy, at least as a thought experiment, and we found it useful as a touchstone. And I think that thread of that discussion did inform the structure of the principles and the holistic view that Amal had described. But I guess a second thought that I have is that it's one thing to say that there is a discriminatory or disparate impact because of these structures and the societies in which the power is operating, or in the global geopolitical context in which citizenship stripping takes place. But it's another thing actually to exercise and to state claims about being a victim of discriminatory impact. My organization does that every day on behalf of many discriminated individuals and groups, and it's a real challenge. And I think going back to what Amal was saying earlier about the subjugation of judiciaries and parliaments to executive power is so critical there, because the principles set this out. We all believe that it's important to scrutinize the discriminatory impacts that citizenship stripping has, but what's the remedy for that really is the question that I'm left with in practice. And I think that is a critical gap, another gap that looms large in this discussion. Stop there.
Thanks, Laura. Did anyone else want to come in on that question? Amal.
Yeah, if I may, very quickly, I just want to maybe reflect a little bit on the question of the Rohingya. So I don't think that anyone with an objective perspective would disagree that a citizenship law which discriminates against and thereby excludes an entire ethnic group from citizenship is problematic. And that's what has happened to the Rohingya, and we can see the consequences of that. Or if anyone would disagree that the practice in the Dominican Republic, whereby a racial minority was en masse deprived of their citizenship, is problematic. And I think sometimes it's useful to think about the obvious cases and try and draw a line or connect the dots between those and some of these cases in the context of counterterrorism. Because actually the underlying principle is the same, where your citizenship is deemed less equal or less important because you belong to a minority or because you have a migrant heritage. And to me, that clarifies things. And it means that you cannot hold the obligation to avoid statelessness above the obligation to not discriminate. You need to adhere to both of them equally. And I mean, just one final thought on that. There's also the problem that by treating certain citizenships as less valuable, you are ultimately treating people unequally before the law. And so this process of privileging citizens by birth or mono-citizens over dual citizens or naturalized citizens means that you are creating two types of citizenship within a framework, and thereby the very institution of citizenship loses some of its integrity and some of its inherent value. So I think these are issues that we also need to be thinking about.
Wonderful. I'm going to ask one last question, I think, depending on how much time we have. There is a question around, is there a difference with deprivation of nationality that is taken by the executive as a discretionary measure, and one that is taken by the judiciary subject to statute and post-conviction? Do I have any takers? Amal?
I mean, yes, because I think the latter is more likely to be ticking the boxes in terms of due process, and that's important. So I would say yes, and I would also say that that type of procedure is probably better equipped to safeguard against the ultimate outcome of a deprivation of citizenship, which is arbitrary or discriminatory, etc. Yeah, so yes, I believe so.
Do I have anyone else who wants to speak to that question?
I mean, I think I would agree with them. I would just say that one of the challenges of addressing citizenship deprivation in the context of national security claims is that courts have historically been more deferential when the context of a particular rights encroachment happens in a national security context, whether it's a rally round the flag problem, whether it's kind of the challenges for courts of being seen to be out of step with the political sentiment, particularly when people are afraid, or there's been a terrorist attack, or there's been a particular sense of a security, whether objectively real or felt, I think the judiciary is not immune from the kinds of pressures that we see, and we've seen that in multiple cases, including in citizenship deprivation cases, where the deference to the state around a national security assessment will still be, I think, quite wide in these cases. And I think so I would agree with Amal that clearly courts, there's a preference for these processes. They are necessary by the relevant international legal standards, treaty and customary law, but they're not foolproof either. And we have to recognize that courts experience enormous stress in the context of high profile cases, particularly when particular individuals become the sort of the carrion flag for a broader governmental policy in taking on the threat of terrorism. And so that, I think, makes the role of courts very difficult.
Thank you.
I would just quickly to piggyback off of that, I think another consideration is the quality and availability of representation in such cases, and in many, the target won't necessarily even have access to the territory. And just going back to the U.S. context in the report, because we were looking at civil prosecutions that were before court, but there was no right to counsel. So 25% of those cases, there was no representation, and many of the cases, and I think this goes to the points being made about how messy any solution is, right? I mean, it's only as good as the strength and independence of the judiciary, and many cases will end in a plea bargain because of the dependence that an individual might have, the risks to family, other inducements that come into play across the process. And you know, I think that I would imagine that operates in somehow in the context, even if we're taking it into a post-conviction posture.
Thank you, Laura. That's very important. What you're saying is that it's that there are a complexity of factors that should be taken account of, even when the judiciary is involved, given the restriction, the ability of persons to be present, and as you said, other extenuating factors that influence that. I am going to be a bit cheeky and ask one final question, even though I probably shouldn't, because I think this discussion is so interesting, and I think this question is so good. There's a question by Florence Carrot, who's asked, would you consider the refusals to issue documents such as birth certificates for people who are with perceived affiliations to armed groups could be seen in the loop of deprivation of nationality as well? And her second part of the question, which I think is really interesting, is how can humanitarian actors be more efficient in addressing statelessness, risks of deprivation of citizenships, refusal to issue legal documents, knowing that it can be quite a political question, and the perception of impartiality of humanitarian actors? And here she is thinking of the Eastern Democratic Republic of Congo in particular, and in Iraq to some extent. Does anyone want to tackle that interesting question?
Well, I will start just by saying I think this is sort of an extension of sort of a broader set of questions. Is clearly the non-issuance of birth certificates, or the non-recognition of birth certificates, in the most obvious practice that many will be familiar with is the issuance of birth certificates by ISIL, which are of course not recognized by any states, leaving large numbers of children currently housed in inhumane and what the mandate views as torture and inhuman degrading treatment standards in camps in northeast Syria. The lack of access to a legal identity for those children, or a national identity, means that of course they are literally outside the law, outside the visibility of the law, and states have found that particularly convenient. The mandate, I think one of the issues I would raise here is, while the formalistic position of many states is that they do not have, there's a non-state actor holding these individuals, it's intensely convenient for those states to have a non-state actor holding those individuals. It is also the case that the states have consistently, a number of states have consistently argued that their lack of access by way of consular representation in those territories means that they have no means of either identifying or engaging the rights to nationality or citizenship of those children. And this seems to me to be really ill-founded. We have seen states do it. I'll give one example. Kazakhstan repatriated hundreds of its citizens in recent years and provided birth certificates and on-site DNA testing to ensure the identification of its nationals. Let's be clear, if one country can do it, most countries can do it. It is a political choice not to do so. And the result is this sort of beautiful doctrinal hair splitting about what is and is not required by the requirements of consular access allows states simply not to engage their fundamental extraterritorial obligations to individuals, many of them minors, all of them in that case victims of terrorism, who are not given the most basic access. This is one of the pressing security and humanitarian and human rights issues of our time, and the collective failure of states to address it, I think, will live with us all, both as a security matter and as a human rights matter for a very long time.
Thank you, Professor Neil. I couldn't agree more. Is there anyone else who wanted to address it? EJ.
Thank you, Yasmin. Yeah, I would just say that this issue and the situation in the Eastern DRC is something I was not aware of. But as a special rapporteur has said, this issue has captivated the international community, the UN, the Secretary General's office. There need to be solutions, but we have to be cautious about suggesting it's easy or is just willful lack of cooperation. But at the same time, as the special rapporteur said, some states are looking into this matter. Kazakhstan is a good example. And it goes back to this question, which is relevant to what we do, which is, how can you bring people into the system? How can you promote policies of inclusion rather than excluding people? And it's exceedingly complicated, but certainly our office urges states to look into concrete steps they can take. And I know many others, both inside and outside the UN, are doing that. And just to say, the question is also very correct in saying that this could put humanitarian actors in a bind. And I think in that case, as they know better than I do, hopefully they can make reference to the legal obligations and hopefully avoid the CT or political pitfalls and just talk about, helping people facing grave humanitarian situations with the support, hopefully, of member states and others. So I think that's the way to go.
Thank you, Jay. I think Amal had his hand up.
Yes, thank you. That's a fantastic question, and I completely agree with both the Special Rapporteur and EJ. But I just wanted to draw attention to the principles themselves because they do address the situation in Principle 10.1. So if you allow me, I'll just read that out. States must not subject persons to proxy measures which do not amount to deprivation of nationality, but which have a similar impact and implications on human rights, without subjecting such decisions to the same tests and standards as set out in the principles. Such measures may include the withdrawal or refusal to renew passports or other travel documents, and the imposition of travel or entry bans. And I think it's quite important because particularly when people are abroad, it's often easier for a state to just not allow them to come back into the country rather than go through the process of depriving them of their citizenship. In terms of birth certificates, I think it's really important to also reiterate the child's right to a nationality and the child's right to immediate birth registration. And what should be an absolute prohibition of the derivative loss of nationality. So holding, in some way, punishing the child for the actions of their parents. And so I think, at least on that, I would hope that there could be agreement. that children born into these circumstances should be issued with documents, however hard it may be to do so, and they should be provided with, they should be able to realize and enjoy their right to nationality.
Thank you, Amal, and thank you for referring us to the principles, which you're quite right, does address this. Laura, did you want to add anything now? No? Okay.
No, I think it's, I like the note of leaving it with the principles.
Okay.
They're the reason we're all together here today. So
Wonderful.
thanks.
Wonderful. Okay. Well, as Laura has said, the reason we are here today is because of the principles and because of the importance of this issue and the fact that we are seeing it being used more and more in the context of counter-terrorism or with other guises, and the significance of the issue and the importance of understanding the multi-layered nature of the issue, both from a policy and a legal perspective. As we've, the Special Rapporteur and other people have noted, there are really prominent examples that we have seen, like the teenager who went out, Shamima Begum, to Syria when she was, I think, 16 or 17, and likely have been groomed and taken out there, and upon the British government finding out she was there, she was stripped of her citizenship. She's now conducting an appeal in relation to that, but she's stuck in a camp in northeast Syria in conditions that the Special Rapporteur noted are in violation of Article 3 of the European Convention, and obviously the ICCPR as well as customary law. So this is a very real issue. It's a very real issue for people in multiple countries around the world, whether it's the Rohingya, whether it's people in migrants or others in the United States. This is a very, very real issue for them and their lives and their dependents. So I want to thank everyone on this panel. I want to thank very much the Institute and OSJI. I want to thank EJ for taking the time, and of course the Special Rapporteur as well. And I really do encourage everyone who has participated today, and I thank you for that, to read the principles. They are translated into a number of languages. If I'm correct, it's French and Russian. And there's also a detailed commentary which has been published with the principles. Now, for anyone who wants to know the basis of each of those principles and wants to understand the law behind deprivation of citizenship and how it may be restricted, I would really encourage you to read through the commentary. I mean, I think the commentary will be an incredibly valuable resource for lawyers, academics, activists to be able to use, because I think there has really been a dearth of that. So I really commend you to look at that. I also commend you to have a look at Laura's and OSJI's report that she's published, which is again really important. We have also, in the question and answer, linked to the Special Rapporteur's intervention in the Shamima Begum case. Again, a really important document that reiterates the principles and engages the principles in the context of that case. So yes, just to wrap up, to say thank you. I think this is really the need for the beginning of a discussion on this issue, and I look forward to taking it forward with the panelists and to those that are participating. And I wish the rest of you a lovely evening, a lovely rest of your day, and I would ask you to please keep this issue at the forefront of your mind, of your writing, and of what you are doing in terms of the importance of safeguarding people's rights. So thank you very much, and good day and good evening.
Thank you, Yasmin.
Thank you, Yasmin.
Thanks, everyone.
Bye.
Thanks.